Good afternoon, everyone. General Gage Wakula, Kayla Carino, and Bill Ralston. What else do we have up here? We have Aubrey Sargent from our Investigations Bureau. And I think we got everybody else. Sorry for the wait. Charges that we issue, obviously we have to wait for the court to sign off on it. And we do our best to estimate how long that will take, but we don't always know. So again, my apologies for the delay. We are here today to announce that my department has charged Ann and Robert Menard for their role in misappropriating funds from numerous legal entities, including 501c4 social welfare nonprofit organizations, multiple state campaign committees, an independent political action committee, an advocacy group, and a lobbying firm, and Rob as his chief of staff. In these roles, the Menards had access to a vast network of well-funded, nonprofit, corporate, and political groups which were tied to the speaker's political activities. The Menards concurrently owned and operated a political consulting firm named Victor Strategies while serving as state employees. This consulting firm served as a tool for the Menards to contract with many of the above-referenced entities and earn fees while consulting, fundraising, and coordinating campaign activities on behalf of then Speaker Chatfield. The Menards held leadership roles in both the House of Representatives and their independent consulting firm. They are Lansing power brokers who choose their clients and undertakings and who boast tremendous access in the realms of government and campaign politics and have the ability to sway public policy, political strategy, and have demonstrated high aptitudes for campaign fundraising. And the evidence uncovered to date supports allegations that the Menards use these professional contractual relationships to financially enrich themselves in a way not permissible within the law. And we allege today that the Menards wrongfully embezzled, misappropriated, or wrongfully obtained a sum of at least $525,000 just from the years 2018 to 2020. And this is important to note because at the same time, between the work that they did, the taxpayer-funded jobs that they held, and Victor Strategies, the other work that they were doing legally, had made approximately $1.5 million during that time period. But this is an additional $525,000 that we allege was not obtained legally. So consequently, Ann and Rob Menard have each been charged as follows. One count of conducting a criminal enterprise, a 20-year felony. One count of conspiracy to conduct a criminal enterprise, a 20-year felony. 3 counts of false pretenses, 1,000 or more but less than 20,000, 5-year felonies. 1 count of false pretenses, 20,000 or more less than $50,000, a 15-year felony. 1 count of embezzlement, $100,000 or more, a 20-year felony. And 1 count of filing a false tax return, which is a 5-year felony. In addition, Ann Menard has been charged individually with 2 counts of embezzlement, 1,000 or more but less than 20,000 from a nonprofit or charitable organization, a 10-year felony, and 2 counts of false pretenses, 1,000 or more but less than 20,000 each, 5-year felonies. Rob Menard has also been charged individually with an additional count of false pretenses, 1,000 or more but less than 20,000, a 5-year felony. Now, I'd like to spend a minute discussing the elements required for each of these charges, with the understanding, of course, that both Ann and Rob Menard are presumed innocent until and unless proven guilty in a court of law. First, that the defendants used a pretense. A pretense is defined as knowingly making someone else believe something that is false or keeping someone else from finding out important information about the property involved. Second, that the defendant knew that the pretense was false at the time they used it, that they intended to defraud or cheat someone, and that they used something of value. We must also prove that the money or property belonged to the nonprofit organizations that the defendant had a relationship of trust with the nonprofit due to their role on the board or campaign, and that they obtained possession or control of the money or property because of that relationship. And finally, that the defendants converted the money or property to their own use and did so with the intent to defraud or cheat the nonprofit of property. Do we have an arraignment date yet? Okay. This is in the 54B District Court. My understanding this has been authorized by Judge Molly Hennessy Greenwalt, and hopefully we'll have that information shortly as to any potential arraignment dates. Now, these charges come on the heels of a nearly 2-year-long investigation that began with criminal referral from the Michigan State Police regarding allegations made against the Menards' former employer, former Speaker of the House, Lee Chatfield. Now, although the initial referral did not pertain to the Menards specifically, as the investigative team continued to uncover and review evidence, it became very apparent that they were intimately involved in a massive amount of financial misappropriation. However, I want to be clear, this investigation remains ongoing, and the Department of Attorney General has not finalized charging decisions in all aspects of the investigation, and that includes our review of any conduct involving former Speaker Chatfield. Now, I understand that I've expressed both publicly and directly to some of you in this very room our intention and our ambition to have this investigation concluded by the end of this year. This case, as you know, is one of many public integrity investigations that my department has been handling, and I believe it's inherent to the public good to set some sort of expectations on when a conclusion can be anticipated. But unfortunately, due to the voluminous amounts of evidence discovered that included millions of documents, emails, records, pieces of data, and procedural rules on gathering the massive number of documents we've received, the investigation cannot conclude by year's end as it pertains to all the individuals involved. I don't like to fall short of any public declarations of intent, but we do have a responsibility to conduct the very best investigation we can for the people of this state, and that investigation must continue. The evidence demands it. And while we're nearing an endpoint, to provide the people a thorough, comprehensive investigation and a sound prosecution, more work must be done, and so it will be. The Michigan State Police initial referral to my department was in 2022. It was complex, wide-reaching, and involved many players and a variety of offenses. And as simple as the allegations might sometimes appear in media reporting, the investigation really has been very far from simple. And today, these charges against these two individuals, now defendants in a state prosecution, represent not where we've ended, but where we began. Now I'd like to turn briefly to discuss the substance of the charges against Ann and Rob Menard. Now, as noted, there are numerous legal entities involved, and those include the following. The 501c4 nonprofits were the Peninsula Fund, Make Michigan First, and Protecting Michigan Future Fund. Also involved the following campaign committees: Julie Alexander for state rep, and Friends of Jim Lilly, and also the Independent PAC Working Together for a Better Michigan. And we have charged the Menards with misappropriations from or misrepresentations made to each of these named entities. During the investigation, it became clear that there were substantial amounts of money involved with these entities that we alleged was handled improperly by the Menards. Now, some of these allegations include the following: submitting invoices to nonprofits for personal reimbursement that showed expenses they did not personally incur or that they did not incur fully, such as by means of presenting estimated expenses, representing them as final bills for sums that were larger than the actual expenses, or by requesting personal reimbursement for expenses incurred by other nonprofit or business accounts, unilaterally moving funds from nonprofit accounts without proper justification to their own accounts, and documenting misrepresented invoices without approval from nonprofit administrators, misrepresenting expense forms, unilaterally using nonprofit funds to pay their own personal expenses, contrary to provided documentation of personal versus business expenses, or even absent documentation altogether. Receiving and keeping for personal gain reimbursement funds from outside entities intended for receipt by a nonprofit, which actually incurred the expense. Invoicing a nonprofit seeking and obtaining reimbursement for costs not incurred by the Menards, but already paid by the nonprofit. Converting nonprofit funds intended for a specific purpose to unrelated and unauthorized business expenses of their private consulting firm, for which separate outside clients had already been paid or had already paid them, and otherwise misappropriating money in their legal possession and then converting that to their own personal use. The terms embezzlement and false pretenses are simple enough to understand. It's taking what is not yours and misrepresenting facts to wrongfully obtain that which is not yours. But the methods and the scheme alleged today are far from simple or easy to follow. So our investigators and prosecutors have worked so diligently for nearly 2 years to uncover what was going on, which included the untangling of tens of thousands of financial records, receipts, emails, and years of communications between Lansing power brokers and hired gun functionaries who often acted like bought and paid for rubber stamps. We've additionally interviewed dozens and dozens of witnesses and interested parties. Just to sort of allow everyone to understand why this is such a time-consuming process, for every financial institution we executed a subpoena on, statutorily they are entitled to 90 days to respond. And then when that information leads us to another financial institution, the clock starts over, and so on. We also used a taint team throughout the course of this investigation and erected an isolation wall separating the reviewing teams from the investigating divisions. Now, the taint team has received potentially privileged documents uncovered throughout the investigation and reviewed them to determine whether or not they're subject to attorney-client privilege. The taint team procedure ensures that the attorney-client privilege of anyone subject to our investigation is preserved, while still allowing our investigators to review documents that are not subject to privilege. And that review process is not complete, and I anticipate our investigators will receive thousands of more documents before all is said and done here. And with that, I really want to thank AAG Gage Wakula and our special agent, Bob Menard, no relation, who worked tirelessly on this case and reviewed an unknown number of documents and have done really an outstanding job of pouring through all this. So thank you so much, Gage and Bob, wherever you are. So one striking conclusion discovered early on in this efforts was this. Of course, these alleged crimes were likely to occur. You know, the environment of money, influence, power, and the feeble regulation in place, the ineffectual reporting standards, the sheer volume of transactions, the staggering sums of money can all too easily become vulnerable to fraudsters, to con men and con women. And today, we're alleging that that is exactly what the Menards did. Political fundraising and spending by those who follow and flout the rules alike has for far too long remained in the dark and hidden away from Michigan residents and from law enforcement. Now, I'd like to be clear about the types of social welfare nonprofits we're discussing today. These types of nonprofits are not giving charitable gifts to sick children or communities in need. They are functional conduits of dark money campaign donors that can accept unlimited contributions from corporations without publicly disclosing their donors. Their social welfare amounts to expensive, politicized speech that is careful to fall just short of endorsing specific candidates. And these funds are more accurately characterized as campaign war chests than anything having to do with social welfare and activity similar to the types of nonprofits those watching at home might donate to. These nonprofits are not required to pay taxes, and they are not required to publicly disclose their donors. And it is so easy to raise massive amounts of money and there are very few rules on how this money can be spent. And that's exactly why they're utilized as dark money vehicles in political campaigns. It's flagrant, it's blatant, and it's obvious, but only when someone has the ability to review it. Our charges represent what we believe we can prove well beyond a reasonable doubt based on the limited statutes available to us. Statutes that in principle aim to curb illegal and unethical behavior. And we intend to prove that this was not an accounting error, this was not an oversight, this was instead a repeated pattern of illegal activity. As our investigation and prosecution remains active and ongoing, there's not a lot more that I'm able to disclose publicly about the alleged schemes for which my department is charging Ann and Rob Menard. The methods employed to embezzle, misappropriate, deceive, steal from these accounts are complex, and it remains difficult sometimes until evidentiary elements are exhibited in open court before a judge and to the public to fully and fairly illustrate the orchestrated flow of nonprofit funds into the private accounts of the Menards. But that is precisely what we've alleged and charged, and that is what we intend to prove in open court. Our investigation will continue full steam on its own timeline to ensure thoroughness, precision, and appropriate care and attention to due process. I do anticipate meeting you all here again in the next few months with further charging decisions and further fruits of our investigative efforts. But again, it is the evidence that will have the ultimate say regarding the timeline. But there is one congruent running theme as we move through these complex cases, and that is, of course, Michigan's campaign finance and political disclosure laws and how they lack clarity, they lack transparency, they lack teeth. It is the weakness of these laws that has made it so easy for people with ties to our government representatives and big money donors alike to skirt the system for personal benefit while also skirting any legal responsibility for their bad behavior. And we allege that the Menards took full advantage of that. These are concrete abuses in black and white, so much so that in some instances, it's obvious that they were counting on the fact that no one would ever review it. Without probable cause to review the internal documents in this case, having a referral from the Michigan State Police, it's likely the public would never see what happened to any of this money. With today's charges, we allege that Ann and Rob Menard didn't just skirt around Michigan's anemic regulation of political spending, but knowingly, willfully, and overtly violated the law for their own personal enrichment. And we intend to prove again that this was no accounting error, but a repeated pattern of illegal activity, a continuing criminal enterprise. And under the shade allowed through Michigan's current campaign finance laws, the Menards hid under the guise of the business of fundraising to repeatedly embezzle money from nonprofits directly, as well as by misappropriating those funds into their own accounts. Michigan residents deserve more. They deserve better than what this flawed system has allowed. As my teams work these investigations, we're also meeting with the legislative work groups that have been formed to analyze and improve Michigan's campaign finance laws. And at the conclusion of these investigations, I will also be sharing very specific legislative recommendations to place additional sunshine on political fundraising and spending, and to make it more difficult for future bad actors to engage in these types of activities for their own personal enrichment. And again, I'd like to reiterate that today's announcement is not the conclusion of this or necessarily any other major public integrity investigation, but the first step in what I hope will lead to not just accountability for those who violate our laws, but a massive culture shift away from the way Lansing currently operates in the dark into what I hope will be a fully transparent and accountable system. So thank you, and with that, happy to take some questions.
Covered it all. John? Attorney General, you mentioned that case was referred to you, initially was focused on Lee Chatfield. Is your office still investigating sexual assault allegations against Lee Chatfield, or is it strictly a financial crimes investigation?
No. All of the other referrals involving anything related to Speaker Chatfield remains ongoing.
Thanks. So that includes the original allegations.
Yes.
Is that correct?
The way these nonprofit accounts have worked is that there are people who put their names down as boards of directors for the accounts that you listed. Do those people have any fiduciary responsibility or legal responsibility to prevent what is happening with these funds?
Well, that's a good question. And it's really unclear to me under the campaign finance laws as they exist as to what that responsibility is, and then also what the penalty would be. And I think what we see oftentimes is you see people who are assigned this that, have a relationship with whoever really is managing that fund, and are told, just sign this, put your name on this, and a law firm or a bookkeeper will handle everything for you. And then every once in a while, somebody will bring you a document, and you'll sign off on it. And a lot of times these are people who, they don't have any particular expertise in managing an account that, again, thousands and thousands of transactions, perhaps millions of dollars coming in and out of that account. I think the biggest problem, of course, is that when you have those individuals that, again, may know very little about what's happening with the account that they might be, on the board of, it's a recipe for disaster. And also, in terms of accountability, even if you were to say sometimes that they had knowledge of that, I don't know what our laws really allow for beyond sometimes just the, 90-day misdemeanor in many instances in terms of the Michigan Campaign Finance Act. And that's why, one of the reasons why it's just so critically important that we have better laws that specifically outline, first of all, what your obligations are, and secondly, what the penalty is in the event that you don't fulfill those requirements or those expectations. But you see it over and over and again. It's a running theme. And then in other cases, it very much appears as though you have the individuals who are benefiting from those particular nonprofits who are named officers of it. So, there are just so many ways in which bad actors are able to avoid any accountability. And I guess what I would say, I had a legislator say to me recently, like, well, no matter what we do, won't bad actors always find a way to cheat or game the system? And I said, I thought about it a little bit in terms of my work as a prosecutor and a defense attorney on bank robbery cases, right? Like, bank robbery, that's pretty appealing. The fact that people could break into a bank and steal thousands, millions of dollars. But you put all these safeguards in place to make it as difficult as possible for that to happen. And that's why you have, these great, alarm systems and surveillance videos and those explosive devices that you put in the bags that, when you get bags of money, ends up, staining everything with red so you could figure out who was handling that. And so by doing so, we make it very, very hard to rob a bank, and we make it very, very easy to discover who's been doing it. And that's why most people don't get away with bank robbery. I would liken that, I think, to our campaign finance laws. If you're going to have incredibly weak laws that really allow for anybody who gets involved in this to take advantage of it, you're going to have a whole lot of people who do that because they know a few things. One, it's easy to get away with. And two, even if you're found out, generally speaking, there's not much in the way of accountability, and because most of the laws don't provide for that. So, yeah, there's always a chance that if you change the law and you make the strictest possible laws, that there will be some people who find some way to game the system. But for most people, they're not going to even want to try. And for many of those who do try, they'll be caught and they'll be held accountable, which, of course, is a great deterrent. But that's a very long answer to your question. But in what we've seen in terms of a lot of these nonprofit accounts, and sometimes the campaign finance accounts, you have somebody, people who are officers on the board, and they just have no idea at all what's going on with that actual account.
Claire?
I'm wondering if in the course of your office's investigation you've uncovered and been able to substantiate any allegations of misconduct by Democrats.
In regard to campaign finance related issues, I'm thinking about our major investigations right now, and most of them are cases where you had Republicans who were making complaints about other Republicans. I have a theory about that, and that is simply this. For so many years in Lansing, you had Republicans who were in these positions of authority. So if you're going to try to influence someone, chances are it's going to be somebody who's got actual authority. And that oftentimes is not people who are in the minority. And so I think it's important for people to understand this works both ways. This type of influence peddling can happen to Democrats just as easy as it can to Republicans. And, what I would say in terms of why we're seeing so much in regard to Republican lawmakers, and not just lawmakers, but of course those associated with them, Republican fundraisers or strategists or staffers or what have you, is because for many years they were the ones who wielded the most power in Lansing. But now that the Democrats are in that position, what I would say is, wait a few years. I mean, if we don't change the law, you'll see the same exact thing. But that's, I think, my suspicion as to why what we've seen is mostly involved members of the Republican Party or those who are affiliated with them. You could spend a lot of time, money, and effort trying to influence someone who's in the minority. I just don't know that it would really get you anywhere.
Yeah, Jordan.
Jordan Hermany was on live. A moment ago you said that there were abuses perpetrated by the Menards in black and white, so much so that it was obvious they were counting on no one to review it. Could you give an example of what you're referring to there?
So I went through a number of examples. I will say this, that I do think that we'll have an affidavit that's going to be available that will provide information that I can't provide to you, but I think that will relay the specific allegations. And so you'll see a lot more detail in that. But in terms of what I can provide in terms of examples, we'll have to wait for that to be introduced in a court of law or the public-facing documents that you'll be able to obtain.
Yeah, please.
I'm Lisa with MERS. Do you have one of these 501c?
In a variety of different ways, and I will say for myself, whether as a public office holder, or prior to this as as an attorney in either in private practice or as an assistant prosecutor in Wayne County, I have always done everything that I could possibly do to ensure that I was abiding by the law. We have these are circumstances obviously where that was not the case, but I guess what I'm saying is that we need to change the rules, and we need to change them for everyone. And I do hear from time to time, well, why don't you voluntarily disclose this? Why don't you voluntarily disclose this? It's like asking somebody, you voluntarily go 55 miles an hour because that's safe, but for everybody else it's discretionary. Let's make sure that everybody is abiding by the laws, and let's make sure that the laws create an environment of transparency, so that whatever, whoever the donors are that are providing these massive amounts of funds, that we all know who they are for everyone. And that in terms of how the money is spent, we all know how it's spent for everyone. And that is what I'm advocating for. We've been having meetings with many legislators now, not for weeks, but for months, not reviewing the specifics of our investigation in terms of, who the parties are or what the funds are, but just what we've been seeing generally speaking in terms of our advice as to how to best change the law to address the concerns that we have I would advocate for first day of session, as soon as members of the legislature are legally permitted to drop bills, that they do so with all deliberate speed, because we can't wait on this any longer. And I will say the thing that these investigations have shown, there are just so many bad actors in so many different capacities, and we're not just talking about electeds. We're also talking about the donors. We're also talking about the lobbyists. We're also talking about the staffers or the fundraisers or the strategists or the many other types of people that are hired to manage these accounts. We're also talking about the law firms. We're also talking about the bookkeepers. I mean, really, the list goes on and on. But that's what happens when you have a total and complete lack of transparency. And that's why we've been working with our legislative partners and advocating tirelessly for changes to apply to everybody.
David?
Dave with Cranes. I was just hoping you could elaborate or clarify how the investigation, which started as a sexual assault complaint, basically got to all these financial charges. And who in the early stages brought it to your attention that there were issues there?
Well, I know that initially it was a complaint made to the Michigan State Police, and that would have been, in December of 2021? Or to the Lansing Police Department? Gage, do you want to elaborate on this? Because I don't want to misspeak, and I want to make sure that you specifically state what those complaints were and when they came in.
Yeah. So I think that specifically the initial allegations came in December of 2021 from the Michigan State Police and the Lansing Police Department. And then there was an additional set of allegations unrelated to the CSC, but pertaining to the misappropriation of finances that were connected to former Speaker of the House Lee Chatfield's political action committees and nonprofits he was associated with. So that's sort of the information that transpired into this investigation. And the investigation started reviewing documents and then started going down certain rabbit holes, and then new documents explained and showed different things that we focused on. So that's kind of how we got to this position today.
Thanks, Gage.
Jonathan?
Yeah, Attorney General, another nonprofit fund that I believe was referred to your office as the Michigan account, attached or linked to former Senate Majority Leader Mike Shirkey. You also said that was a public integrity case you might want to decide by the end of the year. What you decide by the end of the year? What's the
Yeah, that investigation is ongoing. Again, we tried our very hardest to get these wrapped up as quickly as possible. I do want to mention for a minute, so it's clear, a little bit more about how teams work, and that is once the separate investigators or attorneys that have reviewed documents, and a lot of times, there'll be subject terms that are searched, and within the realm of those particular word searches or subject matter searches, that information goes to them. That team tries to review the documents to see, for instance, if there are privileged documents that we're not permitted to review as the investigative team due to attorney-client privilege. Then those have to be sent out to those attorneys, and then the attorneys have a period of time to review those documents before they're, either we are told that, no, these don't violate attorney-client privilege, or, we're contesting that, in which case then we have to go before a judge who has to do an in-camera review and review those documents and then make a decision. So it's a very lengthy and complicated process. And it's why it makes it so difficult for me to ever say, here's the date for certain by which we'll have this wrapped up. So the investigation that you're talking about remains ongoing. Again, I believe it's going to be wrapped up very shortly, but we couldn't do it in time for the end of the year.
Yeah, Craig.
Yeah, so all these allegations, charges are tied to Lee Chatfield. Are there any other people, public figures involved in actions of the Menards? And just for clarity, have the Menards been arrested?
No, the Menards have not been arrested at this point, and it's not our intention to do so. This is the lien now, right? No? Okay. Is it?
Not yet, but
So, right. I mean, we literally came out here as soon as we heard that Judge Hennessy Greenwald had authorized the charges. And so our intention in cases like this, of course, is to allow individuals who are accused of these crimes to be able to turn themselves in and to make those arrangements with their attorneys so that they can be, arraigned on the warrant. So they've not yet turned themselves in, and they'll be given some period of time to do so, at which time, the court will arraign them and issue a bond and bond conditions. In terms of any other individuals, again, I think more information will be forthcoming at the conclusion of our investigation.
Anna Nichols, Michigan Advance. Just to get some clarifying language, because I've heard separate investigation and this investigation as for the CSE versus financial. Are they one investigation, meaning somehow they are tied, that there were players in Lansing that knew about potential CSE, or is it a CSE investigation?
Well, I can't get into the specifics except for to tell you, just broadly, we have specialized CSC investigators and specialized CSC, attorneys or prosecutors. And, we want to make sure that we have people that are specially trained to deal with those types of matters. I think you can understand that handling an alleged sexual assault is wildly different than handling an alleged financial crime. And so sometimes you have different individuals that are involved in terms of the investigation, but that doesn't necessarily mean separate investigations. It might be all investigating together, but you might have different people who are doing different things based on their area of expertise.
Will there be separate expected release dates for charges if they come in the financial component versus the CSE component, or will they be handled concurrent?
As we've not completed our investigation, I can't answer that question.
We have time for about two more. I'll start with Colin in the back.
Colin, Michigan Public Radio Network. Just a quick clarification question. I have in my notes you said they'll be arraigned in 54B court. I'm just wondering, is there any reason for 54B in East Lansing instead of 54A downtown?
Yeah, I think that these accounts were held in East Lansing that we're dealing with, right? Is that correct, Gage?
Yeah, I would just say that the evidence supports venue being proper in the 54B district court.
And I can now announce that we do have an arraignment date, and that is January 3rd at 9 o'clock a.m.
Do it.
Yeah, Joey Kaplan with the Associated Press. You've said a lot today that financial campaign finance laws need to be changed. Your party's been in power for about a year now. Might not be in complete power again until April. Why have things not changed more in the last year?
Well, first I will say this in defense of the Democrats who, majority in the Senate, and now, of course, not anymore as of this moment at least, in the House. But first of all, I think they've done a lot. I mean, there are, an extraordinary amount of legislation has been passed in the last year. This isn't easy stuff. And that's why we've been working with the legislature for many, many months now in order to, help provide whatever information we can. Same thing with the Secretary of State. You can ask Secretary Benson. She's been working with the legislature, too. If you go from a position where you have no subject matter expertise when it comes to this is complicated. And to me, better that you get it right than you get it done immediately. And so what I would say is, yes, I think now that, obviously in terms of having to ensure that Prop 1 from 2022 was complied with, I'm sure was very time consuming. Prop 2, the same thing. And then there were many other things, I think, on the agenda of the Speaker and the Majority Leader. But at this point, I would say that, now with these investigations coming to a head, now with the legislature having an understanding, a better understanding, a greater understanding of exactly what kind of abuse we're talking about, the time is now. And I think we've waited long enough. And it's time for our legislators to start, introducing bills that addresses these kinds of issues and having some really serious debate. But again, I'm going to say this, the allegations here are that you had individuals that were Republicans that stole from funds from, Republican lawmakers from those accounts, as well as these, 501c4s that I imagine were intended to benefit other Republicans, or at least policy promulgated by Republicans. So, this is not partisan. This affects the public trust. It affects people's ability to know who's influencing who and how much influence they have. And that goes for both parties. So obviously the Republicans had a long time to do something and they didn't. But I would really encourage not just the Democrats, but the Republicans to work with them, to work together. These bills ought to be bipartisan, and they should have bipartisan support. They affect everyone in our state, irrespective of how you identify in terms of your political partisanship or affiliation. We're just talking about creating good governance. And the way the law is structured right now, I can tell you, whoever lives in our state and however they vote, voters should want to see systemic change.
Do have time for one more. I'm going to go to Lisa, and then we're going to take our leave.
Lisa with MERS, I have a quick question. I know it's early in the process, but any chance your team has reached out to their attorney for a possible plea yet?
Those discussions will be ongoing, and we'll talk to them the same way we do all criminal defendants in all of our cases, and evaluate an offer based on the circumstances.
Just one quick follow-up on the team. How many people are on it? And while I know you can't identify them specifically, are they made up of attorneys from your office in another section, or are they outside attorneys? Or
Yeah, they're made up of attorneys from our office, and we have a wall that's been erected so that they are separated from the attorneys that are handling, and the investigators that are handling the investigative portions of this.
But I presume they have the expertise in this particular topic.
I imagine so.
And how big is the team already?
I don't know. Do you know the answer to that? Yeah,
Okay.
approximately 7.
Thank you. Sorry about that.
Sure, no problem. All right. Thanks, everyone.